crowd.
All right, welcome to Senate Judiciary. We have a couple of bills today on our plate. We're going to try to deal with three bills because tomorrow is the last day for bills to come out of committee. So we're trying to get through these before our deadline. We will be looking at House Bill 62, then House Bill 83, and then House Bill 223. Pierre, will you go ahead and call the roll?
Senator Crago,
Here.
Senator Crum,
Excused.
Senator Hicks,
Excused.
Senator Kolb,
Present.
Chairman Olson.
Here.
You have a quorum.
Awesome. So the first bill for our consideration is House Bill 62, Prostitution Amendments. Representative Heiner, welcome.
Thank you. Good afternoon, Chairman. Appreciate you taking the time to hear this bill. I didn't phone a friend, but I brought a friend. So I appreciate that if you allow me to do that. This bill is something that we have seen for a number of years. It was Affy's bill last year, and she asked me to carry it for her this year. So it's something that you all have seen before, so I'll just go over it really quickly. Just adjust some of the definitions and some of the criteria for sexual contact, which is not intrusion. So sexual contact means touching with the intention of sexual arousal, gratification, or abuse of the victim's intimate parts by the actor, or of the actor's intimate parts by the victim, or of the clothing covering the immediate area of the victim's or actor's immediate parts. So right now, Wyoming statutes, assault.
Representative Heiner, you're on the unengrossed bill. That definition was changed, it looks like, on the House side.
I have ran into that problem before, Chairman. Thank you very much.
We'll give you a,
Yeah, so we did take out some of that clothing portion.
yep,
Yeah.
Go
So,
ahead.
And you use green where we use blue, so,
yep. I don't know why, but those are the colors.
yeah. So, right now, sexual assault statutes, there are two types of crimes. There's sexual intrusion and sexual contact. So what this does is just includes sexual contact. There's no real recourse when there's just sexual contact and not sexual intrusion. So the meat of the bill is on page 2. We define what an intimate part is and reference statute 62301. But then in subparagraph I, the sexual contact means touching with the intention of sexual arousal, gratification, or abuse of another person's intimate parts by the actor, or of the actor's intimate parts by the other person. And then we struck all this other clothing because, frankly, lap dances didn't want to be excluded. There were some individuals that were worried about that, and I'm embarrassing myself by talking about some of these things. I apologize, Chairman. So then the next section goes into human trafficking statute. Article 7 is all about human trafficking, and it includes the act of sexual contact as defined by that section. And it has to be for money, not just per chance sexual or intimate contact. It has to be for money or other property to constitute prostitution. And then at bottom of page 2, top of page 3, we talk about soliciting, the act of soliciting of prostitution. So where did this come from? Why are we doing this? This all started 5 years ago with the Office of Homeland Security trying to help victims of sexual servitude. And they came into Wyoming, the trafficking task force came in here looking to help combat human trafficking, and they found out that there was no laws that were being violated with this sexual contact. So this is where the nexus of the bill came from. One of the discussion topics may be, well, this will hurt those that are actually victims, those that are in human trafficking situations. But we have the human trafficking provisions in statute that it says a victim of human trafficking is not criminally liable for any committed commercial sex act or other criminal acts committed as a direct result of or incident to being a victim of human trafficking. So I'm not aware of anybody that has actually been prosecuted when they have been extracted from a situation like this. They have been offered services for victims. And so, that this is not to catch those that are being trafficked. It's trying to make it so that we can go in and get them out of those situations and rescue them more effectively. So with that, I have a good friend here to help me, and I'll stand for any questions, Mr. Chairman.
Any questions for Representative Heiner? All right, did you have anything to add, or are you just here for our questions if we have any?
Chairman Olson, Kara Chambers, Wyoming Attorney General's Office, Division of Victim Services, here mostly to answer questions. Just would echo what the good representative has said. This did arise out of the Human Trafficking Task Force, which is housed within the Attorney General's Office and my Division of Victim Services. And so the Senate has seen largely this bill before. So I'm, again, just here to stand for any questions.
Do you know the outcome of the previous bill, Representative Heiner? Did it pass the Senate? Did it make it to the House? And what happened to it?
Mr. Chairman, it passed 30-1 in the Senate. It went to the House and was put in a drawer and never saw the light of day.
All right. We'll see if the Senate remembers this bill. Okay, any other questions? All right, thank you both. We will take public comment. Any public comment? Welcome.
Okay. Hello, Mr. Chairman. My name is Terry Markham. I am the executive director of a anti-human trafficking nonprofit that serves statewide here in Wyoming called Uprising. I started working alongside law enforcement on this bill because we are one of the primary trainers on human trafficking for law enforcement across the state several years back. And at the time, our law enforcement was hitting a lot of roadblocks with having the initial crime to go in and look for the bigger criminal activity that was happening in these illicit massage businesses. So today, I'm going to let these guys share with you more about the law enforcement stuff because that's their expertise. But I thought I'd give you a quick refresher on what these illicit massage parlors actually look like and how they operate. It's something that we have learned a great deal about over the past several years as we've sought out more specific training on this topic so that we could better combat it here in Wyoming. And I feel like as we travel across the state and train on this, there tends to be almost a stereotype that what's happening in these massage parlors is just consenting adults. So why even give it the time of day? But that unfortunately could not be further from the truth. It is actually one of the more heinous forms of human trafficking that I see on my day-to-day work here in Wyoming, because what is typically happening, first of all, the illicit massage parlor industry is basically one giant organized crime ring. And the victims who work in these parlors are pretty much almost scammed to get here to the US to work in these types of businesses. So they come from primarily Southeast Asian countries. They're usually aged 30 plus and have aged out of the working system in their home country. And they come from some pretty extreme forms of poverty. And so they get approached by people who are offering them legitimate work in the US, and all they have to do is take out enormous loans to get here. We've heard anything from $20,000 to $60,000 from survivors of illicit massage parlors, is what they are going into debt for just to basically get the right documents, get on the plane to get to the US. When they get here, their documents are typically withheld from them, and then they are told what they're actually going to be doing is commercial sex. At that point, they're pretty unlikely to reach back out for help because it's pretty shameful in their culture to be involved in commercial sex. And so typically we see that they're going to try to maybe work themselves out of it. The problem is once they actually start working in these businesses, they're usually held in what we call debt bondage. And we've actually seen from sting operations and bust of these illicit massage parlors that oftentimes there's even sometimes a ledger that's kept that shows every time that that person eats their charge, when they take a break their charge. It keeps track of all of their clients. We've even had, we had a woman who was working in one of these massage parlors in Casper who told us she was earning 25 UN per massage. And I didn't know how much that was. I had to Google it. It's about $3.44 in US. So they're obviously not making a fair, livable working wage. Where they earn any money to even send back to their family, which is what they're trying to do, is by earning tips. And how they get the tips is doing the commercial sexual services. And so they're also moved very often, even when there have been like surveillance of some of these massage parlors. The victims in them often will come and go after only being here for a short time, maybe a handful of months. And that's usually very much on purpose to keep them from forming any safe relationships where they might actually disclose or feel comfortable asking for help. And then oftentimes there's, things like threats and stuff. You can't reach out to law enforcement because they're just going to deport you, or your family's going to find out what you've done. Things like that also keep them kept under that control of that trafficker. So what we're really trying to do with this bill is honestly just close a loophole so that law enforcement has that initial crime to get their foot in the door to look for the bigger fish, to look for the money laundering or the racketeering or whatever it is that they find in there, to potentially take down the person who's actually causing the harm, which are the traffickers, the people running these operations and these businesses, and then hopefully be able to offer resources and help to the people who have been working in them. And so that's our overall goal. Like they mentioned with our human trafficking statutes, we were actually the very last state to even put any human trafficking law on the books in Wyoming. But something that's, I think, is really interesting and hopeful about this bill and this specific type of trafficking in our state is because of our population size, we have a handle on potentially how much this is happening. And we've seen in other communities where when they've passed similar legislation, they've been able to close down lots of these businesses in their community. And we actually have the chance to potentially eradicate illicit massage trafficking from our entire state. And if we did that, we'd be the first state to ever do that. And that'd be really cool. So I think this is a really good opportunity to change the climate of human trafficking here in Wyoming. And I will stand for any questions, but you might want to hear these guys first. Thank you, Mr. Chairman. Thank you, council members.
Any questions so far? No? All right. Yeah, Senator Kolb.
Yeah, thank you, Mr. Chairman. Just to the point about shutting it all down, it'll never happen. I think we have to keep a thumb on it like we do with law enforcement, but I don't want the public to think that this is going to stop because of this bill. It's just going to make it easier to prosecute folks because of this bill. So there's just no stopping it. I mean, just to be honest about it, I just can't see how that's going to work. So I guess that was my rhetorical comment. Thank you.
Yeah, wouldn't you disagree? Go ahead.
Okay, thank you. I appreciate your time. Chairman, thank you. Senators, appreciate your time. My name is Justin Scott. I'm a Wyoming native. I've been here all my life. I've been in the service business my whole entire life. I started out as here in Wyoming as a wildland firefighter. I moved on to law enforcement early in my career. I retired in about 2017 from the Converse County Sheriff's Office. I was the undersheriff there when I got hurt in the line of duty. Moved down to Laramie and I started a task force against human trafficking. I've been doing that business for quite a while, or a short time, just about 4 years. But in that time I met Terry and conducted a lot of training. And we go about the state conducting training, and I have a task force of about 30 volunteers, and we try to combat human trafficking from a holistic approach, which looks like not only training citizens, but we also look at serving survivors and victims of human trafficking. We also look at long-term care for victims of trafficking also, and we reach out to the community for various ways of getting awareness out there about this topic. we've heard a lot about the loopholes that we're looking to close and the definitions that we're trying to get into this bill. And I wanted to address just a few topics with you guys today without trying to repeat what Terry had to say. But one of the things that I've done a lot of research on is the legal standpoint of what's happening on, not only what's happening here in Wyoming, but what's going on around us. And when we spoke to the House committee, we chatted a little bit about what happened up in Montana. And we have some partners up there, and back in 2019, they did something pretty similar to what we're asking today. And since then, they've seen a great increase in the success of their search warrants and combating this form of human trafficking, where they have been able to receive these search warrants in a quickly manner to where they can get a hold of the traffickers and the survivors that are inside these buildings, to where they can serve the survivors. And because we have such a hard time tracking the traffickers to the point where we can arrest them because of the time delays that it takes to work these cases. So this would prevent that from happening. And then another thing that I've looked at too is what's happening in Colorado, right to the south of us, is the fact that not only do they have the laws put in place, but they also have city ordinances that we don't have in our small communities up here. Places like Cheyenne and Casper and Rock Springs, some of those places do, and they're putting a little bit of a stop to our illicit massage businesses here in Wyoming. But what Colorado has done is pushed them away and pushed them away and pushed them away. And so they're not going away. They're just moving from place to place. And the recent place that they've moved to is Fort Collins. They've been pushed away from Aurora and Denver and Thornton, and they're just moving away from those from those places, and they're just moving their way up here. So I'm really concerned about that, but I'm also intrigued by what Montana has done to see that we can actually do something to stop that from happening. So with that being said, I really don't have a ton of other stuff that's been I don't want to repeat anything, but I do want to be present here to answer any questions that you guys have about trafficking and what we do here and what we're trying to stop.
Excuse me, any questions for Mr. Scott? All right, thank you. Mr. Thompson.
Thank you, Mr. Chairman. My name is Alan Thompson, the Executive Director of WASCOP, the Wyoming Association of Sheriffs and Chiefs of Police. Our organization had the opportunity to discuss this bill before the session, have strong support for it through the other body and over here. I don't have anything to add other than the testimony that's already been provided today, and also to remind the committee that this is just taking a definition from the sexual assault portion of the statute and adding it to the prostitution. So it's should be nothing out of line from consideration in regular state statute. And I think it it's a simple concept that can mean a big difference in the enforcement of this on the street side. And I would just be happy to answer any questions if you would have any.
Yeah, just based on what you just said, that the definition of sexual contact is being lifted from the sexual assault statutes, is that what you said?
That is correct, Mr. Chairman.
So which version of the definition is mirrored in statute? Because the House changed the definition.
Yes, so Mr. Chairman, the concept of the definition initially changed one word, whether it was victim, and it said changed it to person instead of victim, and that was the only difference from existing language. And then the House amended the definition that included the outer area, clothing above the area.
Gotcha.
And that, to my understanding, is the only difference in the definition. I think that we look at the sexual assault statute, I think it's important to keep that language in the sexual assault statute for that clothing area covering the intimate parts. But it's not as crucial in this definition to have it in there. I think that the definition that we're left with in this engrossed bill still allows the investigators to work these cases the way they need to.
Very good, okay. Yeah, I'm a huge proponent of having consistent definitions across statutes in the code, but I can totally understand why they make sense in this. Even just changing victim to person, I think that's an appropriate change, and it sounds like you guys have done some good work on getting this definition to where it needs to be. Any questions from Mr. Thompson? All right, thank you.
Thank you.
Any other public testimony on this bill? Yes, please come forward. Welcome.
Mr. Chairman, thank you. Kathy Russell with the Wyoming Republican Party. One of the primary issues for Wyoming Republicans this year is illegal immigration and as a subset, human trafficking. Many times we hear from agencies about why they don't want something done, that it's a particular tool they don't particularly want, or if thing can't work. In this particular case, we've got an agency and its subgroups saying we need this tool to push back against a heinous crime. There are all kinds of stories, and they're everywhere, about the victims of human trafficking, and in particular, sexual slavery. It's a big issue, not just here, but nationwide and internationally. Here you're asking, the law enforcement groups are asking for help, and so we stand in support of this bill and ask you to support them. Thank you.
Any questions from Ms. Russell? All right, thank you. Any other public testimony? All right, let's go online. Do we have anyone online? All right, I will close public testimony. Committee, what is your pleasure?
Move the bill.
It's been moved by Senator Crago. Are there any amendments to this bill? Any discussion on it? Senator Cole?
Yeah, thank you, Mr. Chairman. Just to be clear, this activity, according to my local law enforcement folks, has not stopped in Rock Springs. So that's just not true at all. The person who originally brought this bill was Representative Banks out of Rock Springs. That's where this came from to begin with, this whole, he tried to do it back then, but to be clear, it has not stopped. And my law enforcement has reported it's continuing to be a problem, and they are having problems trying to manage it and to deal with it. So thank you, Mr. Chairman.
Any other discussion? Senator Crago?
Thank you, Mr. Chairman. I'd just say I love all these fun topics we get to discuss in the Judiciary Committee.
Welcome to Judiciary. All right, with that, we do a roll call vote on House Bill 62.
Senator Crago.
Aye.
Senator Crum left an absentee vote of aye. Senator Hicks.
Excused.
Senator Kolb.
Aye.
Chairman Olson.
Aye.
4 ayes, 1 excused. Do pass.
You could hand it off to Senator Crum.
And then Representative Heiner, you have 3 Senate co-sponsors on here. Do you know who's doing it? The first one? Brennan? Okay, well, I'll remember that when we introduce the bill. All right, thank you.
Senator Crum is vastly disappointed.
All right, the next bill we have for our consideration is House Bill 83, Child Custody Sex Offense Conviction Presumption. Welcome, Representative Pendergraft.
Thank you, Chairman. I gotta tell you, it's really good to be here, even though the subject matter is a little bit not fun. But it will be a relief to be able to share this one last time and to see this bill go into law. Very briefly, I know I've spoken with each of you and you're aware of the story, but for the sake of people who are watching, my former son-in-law years ago abused his niece. And when that came out, he was convicted. He went, served time, got out, was a registered sex offender. That series of circumstances ended the marriage. And he constantly sought unsupervised visitation of his own children, which included my young granddaughter. And at some point, frankly, to be honest, he was still under supervised, but the supervisor was not very alert. My daughter knew instinctively that she was putting her daughter in harm's way, but was compelled by the state, she felt, to do that. And even though she knew the danger, she had to do that. And of course, as you all are aware, eventually he did in fact molest my granddaughter. And so the opportunity here then comes to place a rebuttable presumption into statute so that in a divorce proceeding or a custody proceeding, a judge would have an opportunity to be reminded and signaled of that. And that's found essentially in Wyoming Statute 20-2-201, but we'll get into that in just a moment. So as you read through the beginning of the bill, it says no sex offender shall have unsupervised visitation with a child. And to me, it would seem like common sense. It's not fair to, it wasn't fair to my son-in-law to put him in that situation. And now he is back in prison, and that has caused other issues. I would say there've been some objections to this bill from folks who maybe they had kind of a silly offense in their past, got caught and busted for one thing or another, and that's not what this is about. I would also state that there are parents who may be in agreement as to what the custody should be, and so far as I'm able to ascertain, generally a judge will first opt for the parents' choices, and so I don't think that's particularly an issue here. As we go on to the bill, page 2, statute 20-2-201 that I mentioned, it begins with granting a divorce, separation of annulment. We're going to go on and discuss what does it mean to be in the best interest of the child. And there are currently 10 items in there that a judge would look at. They include, but are not limited to, quality of relationship each child has with a parent, relative competency or fitness of each parent, the ability of a parent to provide proper care, etc., how the parents and each child can best maintain and strengthen a relationship, all these considerations. And what this bill does, essentially, at the very end, is to insert this rebuttable presumption that begins on the bottom of page 2. When considering an order for visitation, there shall be a rebuttable presumption that it is not in the best interest of the child to grant unsupervised visitation to a parent who is required to register as a sex offender under statute. It is also was made in effect immediately in the hopes that perhaps there is at least one case out there. And I will tell you that I have been contacted by a mother here in this town who is anxiously awaiting this because she's in this particular situation herself right now. And with that, I guess I would stand for any questions.
Representative, the House added in the rebuttable part of the presumption. Was that from outside testimony, or was that someone on the committee? Just trying to figure out what legal minds brought about that change, if you remember.
Thank you, Mr. Chairman. That suggestion had been made several times, even before it got brought to the committee. And by the time it came to the committee, I think I even mentioned it. It might be a good phrase to put in there, because I spoke to several judges, including the judge who presided over this case. And they never mentioned that particular expression, but several others did. And in fact, the judge that presided over the case that initiated this, she flat told me, she said, I really wish this had been there. She said it would have, she said a lot of times you look at a case and you have a gut hunch but you don't have anything written in statute to hang that hunch on. And this does that. And I just wanted to reiterate one last thing. This is also, I think, in the best interest of the potential abuser. You just don't put them in a position where they're going to have trouble with. And we talked about recidivism and all these other issues that are difficult to measure. But I think this is a good step. It doesn't do a lot, but it does give a judge pause in considering the case before them.
Yeah, my only thought, and maybe some of this has been discussed, is, what about taking it to the next step? We're talking about visitation, but in awarding custody by itself, you've got it listed as a factor. But, I could see if the sex offense was against one of the children, in my mind, that should be an automatic, but I guess as long as it's still a factor, the court could consider that, and probably would, most courts would, if the sex offense was against the child, not award custody. But
Thank you, Mr. Chairman. I might comment at the top of page 2, in granting a divorce, separation, or annulment of marriage upon the establishment of paternity, the court may take a decree or an order by disposition of the children that appears most expedient in the best interest of the children, determining the best interest of the child. Perhaps there is another spot in statute. I believe that you guys have a lot more knowledge about that than I do. And if it would be appropriate, then certainly I would be amenable to amending this bill to cover that as well.
Okay. Just a thought I was having. Senator Kolb?
Yeah, thank you, Mr. Chairman. Representative Pendergraft. So you believe this will be retroactive then, for anything that happened in the past?
Representative Pendergraft?
Thank you, Mr. Chairman. Senator Kolb, if it were up to me, it would be. But I honestly can't sit here and tell you that I can understand all the ramifications and situations of that. I would say probably not. A judge has had an opportunity in those cases to look at that and use their best judgment. And then to come back in seems a little bit heavy-handed at this point.
It's not.
I think there could be an appeal.
Well, it's not, there's something in between that. It's not, but it is. The statute does not make it retroactive, but once it's in place, a person could bring an action to modify custody and visitation. They wouldn't need to appeal it. They would have to meet the burden, which is a substantial change in circumstances. But if they could meet that burden, they could bring an action and then use this statute to prevent visitation.
Thank you, Chairman, for the clarification. In fact, that's essentially what happened.
Okay.
In this case, is he was trying to gain partial custody, and the judge was able to go through with all of this in there and put it into a form as that. Anyway, and in this one, in determining custody, she went back to the same statute, 20-2-201. And so as far as I know, that was the only best interest of the child statute.
Senator Kolb?
Yeah, thank you, Mr. Chairman. Representative Pendergraft, this brings me back when I first looked at this bill. My question was, and still is, why couldn't the judge do this if he was reviewing the documents? I don't accept what he had told you, if that's, I'm hearing it secondhand, but I would assume he had the authority to stop this visitation if he so deemed it appropriate. And that's my question about the need for the bill. And thank you, Mr. Chairman. Just a question.
Representative Pendergraft?
Thank you, Mr. Chairman. Yes, Senator, I understand that. If you look at the 10 items that are in there, it's like a checklist. So a judge can sit down and walk through these things. Perhaps there's something that triggers that the judge might not have considered. Certainly, I would expect every judge to be as thorough as possible. But I don't see that it harms anything in putting this in there. And it also gives this judge an opportunity to point to something directly. When I mentioned this, this document that I have here, that is an order granting the mother's petition for a modification of the degree. One section of it is going through the best interests of the child, and the judge in this case cited each and every one of those points. Judge cited each and every one of those points and laid out their thinking in response to that. And so it also kind of makes it public, where it is made public according to, for the parents themselves. I took this under consideration. This is how I came down on it. And I think that was very valuable for me to be able to see a little bit inside the mind of the judge about why she made the decision she made.
Yeah, I think judges are always trying to thread the needle between competing interests, and when it comes to visitation and custody, they have the competing interests of a fundamental right, which is the right to be a parent, versus the best interests of the child, versus the fundamental rights of the other parent, and you're trying to figure out what's everybody's best interest. But I could see, at least in my experience in practicing law, with these types of instances, I can't even recall where there was an instance that supervision wasn't supervised when there was a sex offender involved, or, I mean, when there's someone involved with drugs or alcohol or whatever it may be, visitation ends up being supervised. But I can also see where a judge would be very comfortable having it in statute, telling them they have this provision they can rest their hat on and say, well, it says no unsupervised visitation, sorry. So I think it makes sense. Go ahead, Representative Pendergraft.
Like I said, pursuant to that, I didn't want to feel like I was being heavy-handed and having the legislative branch try to tell the judicial how to do their job. I think that's a problem. So I did go to a number of judges, including 2 Supreme Court justices here in town, and sat down with them at length and talked through this. And every single judge that I spoke to felt like this was a good place for this.
Yeah, we have the courts constantly appear before our committee, so I'm confident that they were tracking this bill, and if they had grave concerns with it, they would have sent someone to let us know. So I feel that what you're representing to us is probably accurate. Thank you. Okay. Public testimony. Anyone in the room wishing to testify on this bill? Anyone, we do have someone online, or not for, I forget I have 3 bills. Okay. Thought we were gonna be done an hour early. Okay, I will close public comment. Committee, what is your pleasure? It has been moved by Senator Kolb. Any amendments to this bill? Senator Kolb?
A question, Mr. Chairman, I don't have an amendment. The question would be, is the use of rebuttable.
Yeah.
That's my question, is that why is that a great improvement, and why was it thought to be necessary?
I mean, Senator Crago can weigh in on this, but I would start by saying that a presumption is rebuttable. So you don't need the language to do that, because the presumption itself is always rebuttable. It means that's the way it works in law, is the presumption says this is what X is going to be the case unless you prove otherwise, and then the other party has to prove otherwise. So I don't think it's necessary. That's why I asked, how did it make its way into the bill? It doesn't hurt the bill to be there. Senator Crago?
I mean, that language, Mr. Chairman, is fairly commonplace in our statutes. So the word rebuttable is used in other places. I think it's fine. I don't think it's anything to worry about. And like the chairman said, it doesn't hurt it, nor does it make it any better. It just, I think it's clarifying.
Kind of rhetorical, in a way.
All right, we do a roll call vote on House Bill 83.
Senator Crago,
Aye.
Senator Crum,
Did he leave, okay, excused?
Senator Hicks left to an absentee vote of aye. Senator Kolb,
Aye.
Chairman Olson.
Aye.
4 ayes, 1 excused.
All right. And Representative Pendergraft, you have you have one Senate sponsor on this, so I know who's going to be carrying the bill. Very good. All right, thank you. The next bill for our consideration is House Bill 223, Preventing Strategic Lawsuits Against Public Participation. You made it, Representative. I was getting a little nervous. I watched the clock winding down. The bills were winding down. You weren't here, but you made it right on time.
Mr. Chairman, I've been preparing and trying to watch Judiciary, or Labor Health as well. But
Very
thank
good.
you very much. I appreciate the opportunity to present this bill.
Yes.
Committee, thank you for your time. I know it's a crazy time right now. So what I have here is House Bill 223, Preventing Strategic Lawsuits Against Public Participation. And what I'd like to do is just open up with kind of what the bill is. I know you're short on time. So a strategic lawsuit against public participation, or SLAP suit, is abusive litigation where a plaintiff brings a legally questionable claim in order to punish the defendant for exercising his or her First Amendment rights. Often, these suits are based upon defamation and other claims arising from expressive conduct. The purpose of a SLAP suit is not necessarily to win, but to inflict punishment of litigation itself. Because of SLAP suits, many people find themselves facing the harsh reality that free speech is not necessarily free. And then I found this interesting, and we have a couple members over there, you might remember Senator Crago, that like to get just a moment of history. The origin of this, in the most important SLAP suit of all time, John Peter Zenger criticized the colonial governor of New York. This was 1733, long before the First Amendment existed as a glimmer in the founding fathers' eyes. In response, the governor had Zenger arrested and tried for the crime of seditious libel. The jury was charged only with deciding whether or not Zenger had published the words. Zenger's attorney, Andrew Hamilton, argued that if a man speaks the truth, no law should punish him for doing so. After 10 minutes of deliberation, the jury rendered a not guilty verdict, establishing one of the first and most fundamental defenses to claims for defamation. Truth is an absolute defense to liability. And I thank you for that. There's some things that the bill does, because I know Senator Kolb was looking at it and was like, okay, what does it do? And I imagine that both of you as attorneys are familiar with it. But what the bill does do, oh, and I just wanted to introduce Jessie Rubino is just here to assist if I need her, if that's okay.
You can bring anyone you want.
Okay, and I have someone online too, so I won't daughter. Okay, dawdle.
Well, I've got a couple of people online. Just tell me which one that is.
Mark Randazza.
Got it.
Okay.
Okay, go ahead.
Okay, first off, it protects First Amendment rights. The bill ensures that Wyoming residents' constitutional rights to freedom of speech, petition, and expression are upheld, allowing for robust public discourse on matters of public concern. It also prevents abuse of legal systems. It provides immunity from lawsuits designed to suppress free speech. It supports public participation. It encourages transparency by reducing the fear of slaps. This bill promotes openness and transparency in public policy discussions, ensuring that voices of all stakeholders can be heard. It protects whistleblowers. It promotes free speech, supports accountability. By preventing slaps, the bill ensures that those attempting to suppress speech or silence critics are held accountable for their actions. It reduces legal harassment. The bill helps eliminate the use of the legal system as a tool of harassment, ensuring that lawsuits cannot be used to intimidate or financially burden individuals or organizations exercising their First Amendment rights. It streamlines the legal process, helps small businesses and nonprofits, protects the media as well,
as business and individuals, promotes fairness in legal proceedings, prevents financial intimidation, strengthens civic engagement. With legal protections in place, Wyoming residents will be more likely to engage in public discussions, advocate for social change, and participate in the democratic process. It expedites resolution of meritless cases. HB 223, also known as the anti-SLAPP bill, enables courts to dismiss cases based on a lack of merit early in the legal process, reducing unnecessary delays and legal costs for those defending their First Amendment rights. It provides legal recourse for victims of SLAPPs, promotes a business-friendly environment, encourages open dialogue, and strengthens Wyoming's reputation. By enacting this bill, Wyoming demonstrates its commitment to protecting constitutional rights and fostering an environment of free speech and open public debate. It aligns with national trends. Many states have enacted anti-SLAPP laws to protect citizens' rights. By passing House Bill 223, Wyoming will join the growing movement across the nation to protect free speech and participation in public discourse. And I'll just say, this bill is strong. We've looked at, the experts have looked at what's been going on over the last 10 years and made this very, very strong and very pertinent to our state. So if you'd like, I'll go over the bill, or we can start with whatever you prefer.
Why don't you walk us through the bill?
Okay. Okay, let me see. A SLAPP is, like it says here, preventing strategic lawsuits against public participation. Beginning on page 2, line 15. Okay, whoops. It's
You're in the
different on here.
wrong, you're in the wrong bill. You should have an engrossed version of the bill.
Oh, I do have engrossed, but my notes aren't for it. So do you want to walk him through the bill? Would that be all right if she does? I have my notes from my other copy. I'm sorry.
that's all right.
I apologize.
Ms. Rubino?
Mr. Chairman, members of the committee, my name is Jessie Rubino. I am a licensed Wyoming attorney, a graduate of the University of Wyoming College of Law, just like the other two attorneys up here. And I'd be happy to walk through this bill. I think from a 30,000-foot view, it does four things. And this is the four things that this bill does. First, it creates qualified immunity for Wyoming citizens engaging in First Amendment activities. 2, it provides the procedure for purposes of invoking this immunity in a court of law. And it operates just like a Rule 12B motion to dismiss in the Wyoming Rules of Civil Procedure. 3, this bill protects Wyomingites from being forum shopped into a state less protective of First Amendment rights. And 4, pursuant to what I just said in 3, this bill creates a positive cause of action for Wyomingites who prevail in a SLAPP lawsuit in another jurisdiction to recover the costs back here in Wyoming. So this discourages forum shopping. Hopefully we'll see less forum shopping in SLAPP cases. There's 35 states who have adopted anti-SLAPP laws, and I think that the Wyoming Judicial Branch and our attorneys are very well equipped to handle this bill if it were to be enacted. If you have any more specific questions, I'm happy to answer them, but just in the interest of time, those are the 4 main pieces that this bill does.
Kind of want to, what I'm trying to get at is I'd like to go through the provisions of the bill, we could at least touch on each section or statute on what it does.
Mr. Chairman, yeah, I can definitely do that.
Okay.
Okay, so let's begin with the notes that we both prepared together from the initial version, but there weren't very many amendments on the House side, so it's pretty simple to go through the bill. So page 2, at the bottom of page 2, the bill just states what the purpose of the act is, which is to ensure full participation by persons in the robust discussion of issues in furtherance of constitutional rights. So we're talking about public issues of public importance, First Amendment protected activities. If you go down to page 3, the first section that you'll see there, that's the immunity that I discussed just a moment ago. So It provides the immunity by stating that all laws in the state are to be construed to grant qualified immunity from suit, prosecution, civil liability for any person in any action, case, claim, administrative proceeding, arbitration, or other legal process that impacts the person's constitutional rights under the First Amendment. And the reason that that's a little bit broad, we were asked this on the, Representative Ottman was asked this on the House side, shouldn't this be caged into defamation? Shouldn't this be more caged in? It's broad because, and we have a friend online who will share some stories. People have been attacked for their First Amendment speech in licensing actions, RICO cases, as you'll see. And so it shouldn't be cabined into a very small number of legal actions. Going on to page 4. Let me see. So at the beginning of page 4, this is really the meat of the bill, and this talks about the procedure. A person may invoke the qualified immunity provided under this law at any time, unless the litigation has proceeded to the point where it's too late in the proceedings and they've been deemed to have waived it at that point. In subsection B there, it also talks about, and it discusses it later on in the bill, there's an opportunity for limited discovery to argue that you are being slapped in the case that you're involved in, and I'll touch on that later when it comes up. Let's see. So the
subsection B, middle of that subsection says that your qualified immunity may be waived.
Yes.
If a person substantially litigates the case beyond a jurisdictional challenge before raising the immunity. So help me understand like an example of where you would be at in the lawsuit that would get you to the point that you were barred or you were waiving your qualified immunity.
Mr. Chairman, I believe that the purpose of that language is to ensure that someone's not substantially engaging in their lawsuit, litigating the case, and then later saying, oh, wait, I want to do this now. The point, as Representative Ottman said earlier, is to dispose of a frivolous case earlier in the proceeding so that it's not wasting the court's time or wasting the party's time.
And then there's an exception to that if they later find through discovery or if it wasn't available, it'll later come upon evidence that would have changed the facts or circumstances, then they don't waive their qualified immunity.
That's correct, Mr. Chairman, and the reason for that provision is it's not providing someone a second bite of the apple per se. It's if facts arise, maybe during discovery, that indicate that this person has actually been pursued in this way based on their First Amendment speech.
Okay, proceed.
Thank you, Mr. Chairman. Page 4. At the end of page 4, starting with subsection C, in any case or lawsuit in which a person asserts that the claims, counterclaims, cross-claims, or discovery against a person are based on their First Amendment rights, then that person may move to dismiss or otherwise dispose of the case. So this is just meaning to say that it's not just a lawsuit against you, filed against you, plaintiff versus defendant. A person can invoke this qualified immunity if First Amendment behavior comes up in a counterclaim or cross-claim or any back and forth piece of a legal action. Moving on to page 5, it just discusses here in Romanet I, a person may invoke the immunity by showing that a claim, counterclaim, or cross-claim is based on that person's use of their First Amendment rights. Romanet 2, the immunity may be invoked if a claim, action, proceeding, counterclaim, or cross-claim is based on at least one action in furtherance of those rights. 3, the immunity shall be afforded to a person if the responding party fails to present evidence or supportable allegations sufficient as a matter of law to establish a prima facie case regarding each element of the claim to survive a motion to dismiss. So it puts that burden of proof back on the other side to say, no, this isn't actually based on this person's First Amendment activities. We actually have a legitimate case here. And I'd like to just say at this point, anti-SLAPP lawsuits are not meant, or anti-SLAPP laws are not meant to prevent legitimate legal actions. And most of the time, SLAPP lawsuits aren't even filed with the intention of winning. They're just filed with the intention to harass. And so it's why it's important to allow that party that filed the suit to prove that it is actually meritorious, but to do it early on in the case. And so I'll just reiterate, this bill wouldn't prevent the filing of meritorious lawsuits. It's meant to deal with frivolous lawsuits earlier on in the proceedings before someone is, completely dried up of all of their funds and will to continue on. Okay, so moving on to page 6, if you want me to keep going this slow, Mr. Chairman, I know it's kind of a beast of a bill.
You're fine.
Okay.
I mean, you don't have to necessarily go through every subsection. like,
Okay, just the bigger sections, is what you'd
Yeah.
like?
Yep.
Okay. So just from where I left off, let me scroll back up, make sure I'm not leaving anything big out. So the procedure is what's found pages 3, 4, 5, 6, 7. When we get to the top of page 8, that's when we will see a little bit more on the procedure piece. This is relating to the federal courts and foreign jurisdictions. This is the portability piece. So in federal courts and other jurisdictions, the rules are severable from the immunity. So this is just, and I think Randazza can kind of help us a little bit with this piece, but I believe this is what kind of helps to thread the needle with the Erie doctrine. So if a case is found in federal court and someone's being sued in federal court, as you know, in federal court, a state's substantive law is used and then the federal procedural law is used. This part is to state that the qualified immunity here is the substantive law. So a federal court can't take the qualified immunity and say, oh, this is merely procedural, we're going to toss it aside and use our federal rules for this piece. Let's see, that we also have more in subsection B there, motion to dismiss based on immunity shall be filed not less than 7 days after notice of intent to file a motion to dismiss. I believe that this timeline was a little bit concerning to people on the House side, so I don't know if there's something here that the committee would like to look at in terms of that 7-day deadline. If you go on through 9, we're still talking about that procedure there. 10 is more procedure. 11 is more procedure. On page
Yes,
11, that's
Senator
where,
Craigo has a question.
oh, yeah.
Thank you, Mr. Chairman. Mr. Rubino, go back to that, because I'm not necessarily worried about the time, 7 days or whatever, page 8, lines 16 through 19. Walk
Sorry,
me
can you
through the notice of intent. So it says a motion to dismiss based on the immunity provided in 144-102 shall be filed not less than 7 days after a notice of intent to file a motion. So you have to file a notice of intent before you file the motion, or fill me in on that if you could, please.
Ms. Rubino.
Thank you, Mr. Chairman and Senator Craigo. So this is meant to allow the plaintiff, I guess, a chance to come to their senses before you are trying to throw out their entire case with this anti-SLAPP provision. So it's providing the other side to, again, either come to their senses or prepare themselves to say that this case is meritorious. It's kind of a fair play type of a thing for the plaintiff.
Right, but just trying to think of this like in our rules of civil procedure, I don't file a notice of intent to file my motion to dismiss. I just file a motion to dismiss. So is the notice of intent somewhere in the statutes here? Is that a new procedural step that we're creating, or?
Mr. Chairman, that's a good question. I do believe it would be new, and if it's something that this committee doesn't think is necessary, then I don't think it's necessary to the bill by any means.
Okay. Go ahead.
Okay, let's see. Thank you, Mr. Chairman. So pages 10 and 11, I discussed it a little bit earlier. There are procedures to obtain limited discovery in a motion to dismiss based on the qualified immunity provided here. Let's see, moving down to the bottom of page 12, you can see here the bill discusses and provides separate actions and counterclaims. The procedures there are the same as the other sections of the bill. On page 14, subsection C, and also I guess on page 13, subsection B, and then all the way through, that's that portability portion that I had discussed earlier. So 13, subsection B, if a strategic lawsuit is brought against a person and the person successfully invokes the immunity under this chapter, the person may bring a separate action to recover costs and attorney's fees. So that's if it's filed in Wyoming. If you continue down into page 14, if the case is brought in another jurisdiction that doesn't have an anti-SLAPP law, but the person could have prevailed in Wyoming with an anti-SLAPP law, then they're able to file in Wyoming to receive their fees back for being abused in another jurisdiction. So it's meant to protect Wyoming citizens from being forum shopped into jurisdictions that don't have anti-SLAPP laws. And like I said, 35 states do, we'd be the 36th. So hopefully that's not really a thing to worry about as more and more states jump on this.
Senator Craigo?
Thank you, Mr. Chairman. Mr. Bino. So I'm just trying to walk through this. So if someone files, let's say a Wyoming person gets sued for libel defamation in a different state, loses the case, right? The claim was found to be viable, but then they can still come back to Wyoming and file a claim against the person who beat them in another state. I mean, that's how I read this. Tell me why I'm wrong.
Mr. Chairman, Senator Craigo, if I'm correct, the portability and the cause of action would only apply if the person was successful in the SLAPP case and if they could have successfully dismissed the case pursuant to the anti-SLAPP in Wyoming. It's only if you win in the other jurisdiction. So again, it's not meant to kick out meritorious claims. If you defame somebody, we all agree, we're all First Amendment absolutists. I think nobody should be allowed to defame anybody, but no one should also be silenced for saying something that might be inconvenient or irritating.
Just jumping back to page 8 under 1-44103, there's this provision about federal courts. How do we do anything in statute that is binding on a federal court? Why are we referencing a federal court, and what are we trying to do with that federal court?
Mr. Chairman, I would like to phone a friend for that one. I apologize. I have, Mr. Randazza online has litigated many of these cases, and so he's better equipped to answer that specific question.
We will save that one for him. You made it to page 14 last time I was up to speed with you. Are you still explaining the bill, or where are we at?
So 14, Mr. Chairman, we just briefly discussed that in addressing a few of those questions from Senator Craigo about prevailing in the foreign jurisdiction, and that term, if at the bottom of page 14, line 20, if the person prevailed in that foreign jurisdiction, then that's that piece there to provide a little bit of authority for that there. Page 15 discusses statutory damages for a person who does prevail in another jurisdiction or prevails in Wyoming and brings a suit to recover their costs. They can receive statutory damages of not less than $10,000, not more than $100,000. Damages equal in amount to the actual costs and reasonable attorney's fees incurred, and then all costs and reasonable attorney's fees incurred in the cause of action. So page 16 is just applicability and the effective date. The effective date, I'd like to make one brief comment on when this bill was originally introduced, it applied to pending cases, and that was wisely amended out to just apply to future cases after this is enacted.
Senator Craigo?
Thank you, Mr. Chairman. So looking at applicability there, 144-105, it says this chapter shall apply to all actions in the state of Wyoming. So you think it still exempts out pending actions?
Mr. Chairman, Senator Craigo, yes, it would. The wording "all actions" is meant to be in it's what I discussed earlier. The breadth of this. It's not meant to just deal with defamation actions or licensure actions or libel or whatever actions. It's meant to apply to all actions in the state of Wyoming, and then that section 2 cements the fact that this act is effective immediately upon all completion of acts necessary. If this committee wants it to be more clear and specifically state that it only applies to actions filed after the effective date, then that doesn't harm the intent of the bill either. There's no desire to change a pending case and upend anything that's currently before the courts.
Go ahead, Senator Cole.
Yeah, thank you, Mr. Chairman. Just a general construction question. As I'm looking at this document, it seems almost like it was trying to address a federal regulation and not a state statute. I mean, some of the words you chose to use in here, page 3, line 15. All laws in this state shall be construed to grant qualified immunity from a suit. Why wouldn't it be more Wyoming specific? I mean, it just smacks of something that came from somewhere else. I'd like to know where this grand thought came from on how to attack it in this manner. That's my question.
And maybe just to tack on to that, I was going to ask this earlier. I had a question about how many states had introduced or had, I'm sorry, passed anti-SLAPP laws. I think you said 35, but I was curious if one of those 35 states is where this language comes from, or maybe you could help us understand where we lifted this language from.
Mr. Chairman, committee, yes, and Senator Kolb, to answer that, and we can phone our friend. But what I will say is that these bills have been coming up for years. And like I said, it started in 1733. But this particular bill, our Mr. Randazza created the, he has dealt with them, but he created the bill that was put into effect in Nevada 10 years ago. And as the creator of that, and also it goes along with a lot of business entities, First Amendment, and all of those things. With that, that bill has stayed in place for 10 years. And so at this point, this bill is based on that bill and all of the improvements that they've seen over the years. So it is just like the best for business, for individuals, and for the time in which we live. We have not lived in a time where there has been the social media and the things like we have. So to make that, and I don't want to take up any more time if you're looking to hear his testimony, because he'll be able to explain it to you at a lot. Thank Ms. Rubino very much, but if you would, just go ahead and if you would admit him or public comment or whatever, and then if you still have questions, I'd be glad to do that.
Okay. Any other questions for Ms. Rubino or Representative Ottman? All right. Public testimony? I don't see any agencies. Mr. Carenti? Ms. Russell?
Mr. Chairman, Joey Carenti. I'm the president of the Wyoming Digital and Multimedia Independent Trade Association. We've stood up this morning, and we probably already have a defamation lawsuit against us that could be handled by this. One of the things that catches my attention is the language in our own Constitution. I believe it's Article 1, Section 20, that says you have the right to free speech, but you have an inherent responsibility. And it specifically says anything going into the court having to do with libel. Doesn't say anything about slander or defamation. So there's a lot of confusion because those three words get mixed up and only one is actually used in our Constitution. It covers individuals and what's considered press or media. We don't know what that means anymore, especially with my association. We're independent tradesmen who utilize digital multimedia. We're not part of a newspaper. I'm definitely not a journalist. People call me that all the time. I don't know what to call it. So when I face legal action, which you guys know I do all the time, possibly spend more time in court than the lawyers here, my personal property, even though I have an LLC, they say, Mr. Carenti said this, and they come after me. And a lot of the times it is just that. It's frivolous, and it's time consuming, and it's meant to be time and cost prohibitive for me to get through that. So I don't know that the specific machinery inside this bill is exact. I see a lot of hesitation and concern in the committee with the way this Rube Goldberg thing actually would work. But the spirit of it, I think, is very important. I'm on and for the bill. Of course, I don't understand what it does except for say, I don't have to go through all the things I normally go through when what comes out of my mouth comes out of my mouth, even though I can back it up with facts and data. So with that, I don't want to overstress the importance to certain industries that are emerging that really aren't contemplated throughout our laws or Constitution yet. And this may be the first good step, at least in the posture that this bill is proposing, to start addressing some of those things, because we are having these emerging markets that are taking over traditional media. We're not newspapers. That's very specifically defined in statute what a newspaper is. Again, I'm not a journalist. I have a badge from this building that says I'm media. I don't know what that means. I'm not a blogger. But again, I think we're facing a lot of things where in Wyoming, we're taught to be tough, but be fair and do what needs to be done. And sometimes that gets you stuck in a defamation lawsuit. And if it's frivolous, I think we need a way out of it early. So with that, I'll stand for any questions, Mr. Chairman.
Any questions for Mr. Correnti? All right, thank you. Ms. Russell?
Mr. Chairman, thank you. Kathy Russell, Wyoming Republican Party Executive Director. Lawfare is a growing issue across the nation and certainly in Wyoming. I personally have experienced some of the effects of lawfare and the inception of lawfare against a group I'm associated with. So conceptually agree with pushing back on this. Over the last few decades, we have seen a decrease on the role, or in the case of judges, initially declaring a frivolous lawsuit. So that has given rise to what we now call lawfare. I'm curious to hear the testimony coming from the person who is online, but in effect, this would help discourage people from bringing what we would previously call frivolous lawsuits and putting a monetary discourager on there of the recovery, partial recovery anyway, of costs associated with the frivolous lawsuit brought against someone unfairly. So conceptually, we would encourage you to bring this bill to the floor for debate because it's worthy of debate, we believe. Thank you, Mr. Chairman.
Any questions for Ms. Russell? All right, additional public comment? Welcome.
Welcome. Thank you, Mr. Chairman. My name is Colin Crossman. You might know me. I work for the state. However, I'm here 100% in my personal capacity and not as an employee of the state. I apologize for missing the earlier components of this. However, I did want to answer a question that I was told that did occur during the initial presentation about the severability component. That is under 1-44-103, and the severability component is the Erie Doctrine fix piece because the federal courts are not required to respect state procedural doctrines when they are interpreting state law. They do, however, have to respect state substantive law. And so by creating the immunity as a severable component, which it becomes a substantive piece rather than a procedural piece. And so the federal courts are required to then keep that in place. They can completely ignore the procedural piece, but they can't ignore the substantive piece. And that's what that is for. I could go into briefly a little bit about why I strongly support this act. I think I've mentioned to many of you some of the history that I've had, but I was sued for defamation in a situation where the utterance was clearly not defamation, is protected speech. I fortunately had an insurance company that was able to and willing to fight to prevent that from going all the way, but it still cost them about $250,000 thereabouts to defend to a nuisance settlement. But that is, having that personal history is why I'm very interested in these sorts of laws. I also used to work for, years ago, for the FIRE, used to be called the Foundation for Individual Rights in Education. They've since changed their name, and I can never remember what the new name is because I know them as FIRE for 20 years. But with that, I'll just stand for questions.
Senator Crago?
Thank you, Mr. Chairman. Thank you, Mr. Chairman. Mr. Crossman, the good chairman, while you were gone, asked, there's other states that have similar type laws, and the question was, well, where did this particular language come from? Does it mirror a different state? The good sponsor said something about Nevada. I pulled up Nevada's. It's not like this. So do you know where this language came from, or if there's another state that has language similar to this? Thank you, Mr. Chairman.
Mr. Crossman?
Thank you, Mr. Chairman. Senator Crago. the Nevada statute was the impetus that this was built off of. But this was a work between myself and another attorney who I believe is remote, Mark Randazza, and we put it together for that purpose to make it, because, well, one of the issues was to look at what Nevada had done. Nevada's is, up until now, probably the best in the country. I believe that this goes further and fixes some of the things that have been identified. For instance, the severability of the procedural component in the federal courts. It fixes those out of the Nevada statute and makes it better. But this was designed for this purpose here.
Follow up, Mr. Chairman?
Yes, go ahead.
So just to follow up, there is not another state that has this language. This is a one-off or one of a kind that you guys worked on, so to fit Wyoming law.
Yeah. Mr. Crossman?
Yes, Mr. Chairman, Senator Gray, yes, that's correct. We put that together, and for instance, one of the things about Wyoming law that had to be put in here was sorry, I will forget the case citation. However, there was a Supreme Court case that required not immunity from liability, but the word in the statute to be immunity from suit. That is one of the things that is specifically embodied in here to respect the Supreme Court of Wyoming's decision in that case.
Any other questions for Mr. Crossman? No? I'm just curious, we talked about this while you were gone. On page 8, subsection B, is walking through a procedural mechanism to file a motion to dismiss. And it says that a motion to dismiss shall be filed not less than 7 days after a notice of intent to file a motion to dismiss is served on the opposing party. To me, that is very new language in the Wyoming Rules of Civil Procedure. I am not familiar with any type of motion that you would file providing intent to file a motion to dismiss. Is that language specific to some state you were looking at, or what were we thinking with that?
Yes, Mr. Chairman, thank you. I will have to defer to Mr. Randazza on specifically where we got that. However, I believe the reasoning is because this is the unique aspects of this being a special motion to dismiss. We wanted to make sure that everyone involved is aware, so that you can't just spring it. So there has to be some sort of we understand that what this is doing is creating an additional bar for these types of cases, to make sure that that bar is not a surprise, and this is not a weapon to be used by people, that this is purely a defensive thing, that there is an additional level of responsibility on the defendant to bring it properly, and having a notice to the court and the other party that is being done. I think you can answer that, but if I will defer to Mr. Rendaz on that.
Okay. Any other questions for Mr. Crossman? Senator Craigo?
Thank you, Mr. Chairman. So going back to the Nevada law, and I'm sorry, it's just trying to get through some of it as we're hearing testimony, because didn't have that ahead of time. Apologize. You probably sent it to us, actually. So the Nevada law in particular applies to comments made in the public realm or to a public official in furtherance of your right to petition your government. Really, that's what that particular law is. I mean, that's the focus of that law. Is that correct, Mr. Chairman?
Mr. Crossman?
Yes, Mr. Chairman, Senator Krieger, I believe that is correct. This one is a little broader because it does cover the entirety of the First Amendment.
And that was going to be my next question, Mr. Chairman, was that this one appears to cover all types of communications, not just those to petition your government.
Yes, Mr. Chairman, thank you. This covers, so in a situation where you were, for instance, if you're a podcaster and you were to state something that is clearly an opinion, protected First Amendment speech, not in the process of petitioning your government, you're informing or entertaining the public. But if you're doing that and you can't be attacked through this barratry process where it's obvious that the statement is not, no amount of discovery would turn this statement from an opinion to a fact. or would remove it from the First Amendment protections. What the anti-SLAPP does is puts an additional, a first pass so that the court can just get rid of it without having to go through the discovery necessary, or not, the discovery that would be unnecessary in those cases when you can easily make a prima facie case to get into discovery when it doesn't matter. It's plain on its face that it's not going to matter, but the standards are such that the judge will often allow it to go through full discovery. That's the punishment that SLAPP cases are designed to do. This is also not designed to stop a valid meritorious defamation claim. It would provide a little bit of a speed bump, but that's it. A meritorious defamation claim that the standard of proof to get past the anti-SLAPP is fairly low, and it does allow for limited discovery in this situation where, let's say, the person being defamed is a public official, and you need a little bit of discovery to determine if the New York Times v. Sullivan aspect of actual malice is present. That discovery can be requested and granted by the court. You just don't get the ability to go into the person's full financial records and all of the aspects of discovery that can be done and often are done in the sort of traditional SLAPP case.
Thank you, Mr. Chairman. You would agree with me, though, that it will have a cooling effect on defamation cases, because if for some reason you happen to lose your defamation case, we are creating an attorney's fees provision that does not already exist, correct?
Mr. Crossman?
Thank you, Mr. Chairman. You are correct at a first approximation. And I say that because, yes, there is a, we are creating an attorney's fees provision here that doesn't already exist. However, the attorney's fees that are likely, because this is so early, are very low. You're not going to go through a year to get at a full dismissal before. The anti-SLAPP is an early motion that's done, and I believe at one point in here it does say if you don't do it early enough, you waive it. I don't want to spend time just specifically looking it up, but that is in there. So yes, there might be a slight cooling effect in someone who is not entirely sure of their claim, but as others will probably say, if you are consulting an attorney and they are telling you, yes, I can bring this claim, and you have an anti-SLAPP there, it actually will make your case stronger, because your attorney and the other attorney and the judge will know, especially, you're going to draw an anti-SLAPP on this case. Are you prepared for that? Yes, sir, I am. Okay, well, now your attorneys have done a little bit more due diligence to make sure that they're actually going to get past that. So the case is likely getting an earlier stage of vetting, and they're not going to bring a case that is very weak.
Senator Golden?
Yeah, thank you, Mr. Chairman. Just a person looking at this and looking at balance. Why shouldn't the person who brought a SLAPP case be responsible for all the costs of their side's attorney's fees if they lose such a SLAPP case? In other words, a slap. So you try to pull this and you lose. Let's just say it doesn't work, your argument fails. Why wouldn't you then, in fairness, be responsible for all the other person's cost of attorneys? If you're going to, I see it going both ways. So I don't know. Tell me why you shouldn't bear responsibility for losing a case like this where you enact this type of, I guess, ability. I'd like to hear, why would that not be fair for you to pay the fees?
Mr. Crossman?
Thank you, Mr. Chairman, Senator Kolb. If you get to the final resolution, you'll have your vindication there. What this is, yes, the costs of this are at this point are borne by the individual parties. Yes, but the costs are very low. We're not talking about hundreds of thousands of dollars. We're talking in its early stages, and a judge can always sanction. So what is protected speech and what isn't can be pretty clear. It doesn't always, I admit that, but it can be pretty clear. And if your statement is a statement of fact that would not be tractable with an anti-SLAPP motion, the judge can still sanction the attorney and sanction the party through the means that we already have. So we do have those protections in place for filing a frivolous motion. The thing is, what is considered frivolous in the early stages of a case, that would be a completed act. But if you're looking through the whole of discovery, you may not know that the judge may not be willing to dismiss. In my case back that I was telling you about earlier, the statement was clearly protected. The judge didn't care, wanted to go all the way through discovery before, and it took 2 years. So if I had this, yes, I would have used it. Could I have used it offensively? Yes, but it would be a needle prick versus being run over by a truck.
Senator Crago.
Mr. Chairman, for what it's worth, the Nevada law does provide the exact remedy that Senator Kolb was just talking about.
You have some follow-up there, Senator Kolb? Go ahead.
Yeah, just a concern, a follow-up is that when I hear that a law was then improved from an existing law, I'm always very curious on what these improvements were, because I'm voting, 0% good improvements. So I really wanted to know exactly what the improvements were, and I think you've done a job. Maybe if you wanted to explain any more that's in here. I am highly concerned about, as they say, sprinkling the good on, because it doesn't always happen to be good at the end. But if you any more justification for, I guess, enhancing, or I shouldn't say changing, the Nevada law. Thank you, Mr. Chairman.
Mr. Crossman.
Thank you, Mr. Chairman. Senator Kolb. The specific improvements that I had called out are fixing the Erie Doctrine problem, so allowing the anti-SLAPP here to function in the federal courts. Then the second one that I specifically point out here is I called it portability. I think others have called it slapback, but this is a provision where if a Wyoming entity, citizen or a commercial entity, is sued in a separate jurisdiction that doesn't have these protections or isn't afforded these protections and wins anyway, they can bring a claim in Wyoming for what they would have been owed had they been able to use this. So this is that aspect of it protects from forum shopping. So if you, for instance, right now, if you're a Nevada citizen and you the vast majority of these defamation things are through the internet or through publication, right? So it's worldwide. So what if you're sued in, say, Florida that does not have a good anti-SLAPP law? Or I'm not 100% sure if it even has one, but if it does, it's not very good. Or you're just not afforded that there, and it's you win because it's clearly a First Amendment protected thing. You can then come back, in a Wyoming citizen under this would be able to come back to Wyoming and get their attorney's fees covered, whereas a Nevada citizen, even though they have a good anti-SLAPP, would not be able to. So people can avoid the Nevada law by using federal court or by filing in other jurisdictions, whereas the Wyoming law is attempting to prevent that kind of forum shopping or minimize it at least.
Other questions for Mr. Crossman? All right, thank you. Other public testimony in the room? If not, we will go, Mr. Crossman, I did have actually a question. I understand the construction of this bill took place between you and Mr. Rendaza primarily. Did you run the bill by any judges, any other members of the bar, any attorneys associations, any of the other kind of actors in our state that might be able to weigh in?
Thank you, Mr. Chairman. Yes, not associations. I consulted, I talked with several other attorneys that I'm personal friends with and discussed. There's no budget or anything for this. So it was all, off the clock, extemporaneous time. So I communicated with attorneys that I'm friendly with and we discussed it. I also reached out to friends who are in the First Amendment space. But as to going to, say, the state bar, I did not do that, no.
Okay. Thank you, Mr. Crossman. With that, we have no more public testimony in the room. We will go to online testimony. We have how many people? Two? We have about 5 minutes. So why don't we get Mr. Rendaza in here? Welcome, Mr. Rendaza. We have about 5 minutes left to take testimony. There are two wishing to take testimony, so maybe just a couple minutes from you. Tell us what you want us to hear, and then so we can at least get to that last person before we have to shut off public testimony.
Okay. As you heard, I did assist with the drafting of this. Hearing that it is a great improvement over Nevada's, I have to take a little bit of umbrage from that because I was the author of Nevada's as well. But I'm not too proud to say that, as my child has grown up, it has shown some imperfections and shown some problems. I have litigated these cases for about 25 years. I've assisted with drafting this legislation, not just in Nevada and here, but in New York, Pennsylvania, Ohio, Tennessee, and God, I can't even remember how many legislatures have called me to ask for input on them. And so the body of knowledge that I've gained from doing that has shown me where there are imperfections that could be improved upon as each state goes by. For example, Pennsylvania just enacted a statute that had some of these improvements in it where it was careful to separate substance from procedure, as this one does. That wasn't necessary back in the early days of anti-SLAPP laws, and Nevada's doesn't do that. However, the Ninth Circuit has interpreted the substantive provisions to remain in federal court and the procedural ones not to. However, there are problems in other circuits where the circuits have simply not been able to disambiguate the two. This does that. There was something that was brought up earlier where I think there just might be a slight bit of misunderstanding about one of the provisions, the 7-day notice. This is sort of like when you have all three of the August members of the bar are litigators. Am I correct, Mr. Chairman?
Are you talking about of our committee?
Yes, sir. The three gentlemen here asking questions I presume, given the questions, are all litigators.
Two out of the three of us are attorneys and one's a gentleman.
Okay, well, before
Thank you.
before you have, for example, a discovery dispute, you're required to have a meet and confer. That's because the courts don't want to hear from you if there's something you can resolve without making it the court's problem. Therefore, what this requires is not that you file anything in advance, but simply that you provide notice. So if I'm about to file one of these, I have to call my adversary and give them notice. Hey, by the way, if you were sloppy or you just didn't take this into account, I want to let you know this is coming. That's a matter of, I think, fairness that doesn't exist in Nevada, that favors the plaintiff. If a plaintiff files something like this, they deserve to know that the hammer is potentially coming. Another thing I wanted to address is the fact that this does give a significant amount of I'd say, ammunition to a plaintiff if one of these is filed poorly. For example, if you look at the discovery provisions, you have to seek permission from the court to get discovery. And as Mr. Crossman testified, think about if you have something where it's clearly a matter of opinion or clearly a matter of public concern protected by New York Times versus Sullivan. No amount of discovery is going to change that. However, let's say I'm the defense attorney, the plaintiff's attorney calls me and says, there is this one fact that I'm not going to be able to defend against your anti-SLAPP fairly if you don't let me have discovery on it. The bill says if I don't give that permission reasonably, I'm going to have to pay his fees for having brought the motion. So it does have a balance if you look at both sides of it. And there was a really good question, really liked, where I forget which one of you asked, but does this chill defamation cases? I do defamation cases on both sides. I am not a purist. In fact, I would venture to say I make more money on plaintiff side defamation cases than I do on defense sides over the past few years. I have no fear of anti-SLAPP laws, and I would not fear this one because I would not bring a case that could not get past this low bar that this creates. What it does is it does kill off the weak of the herd, so to speak. But a herd is always more healthy when that happens. So I don't think you're going to find that legitimately damaged people are going to find themselves chilled. And I do know that when you walk into a courtroom in Nevada with a defamation case, a court will have considered, did you think about whether the anti-SLAPP law would be invoked here? So I do believe what it will chill is people using abusive litigation in order to chill others. But I don't think you're going to have a problem with people unable to find themselves vindicated if their reputations are genuinely damaged.
All right, Mr. Rendaz, I have to end you there. We do appreciate your testimony. We have to get to.
My pleasure. I would like to add one thing to this, if you would, if Mr. Chairman, if you could indulge me, is that the competitive advantage that this is going to give to Wyoming corporations over, for example, Delaware that has no anti-SLAPP law, and Nevada. Unfortunately, this is going to, if this passes, it's going to very negatively impact my corporate registration practice. But so be it. I'm here to tell the truth. And if Wyoming steals that business from me, well, then maybe I'll just have to get barred in Wyoming.
Very good. We welcome you here.
Thank you, Mr. Chairman.
All right, thank you. And then Mr. Arnowitz, we have just a couple of minutes. If you could just keep it to a minute or two, I'd really appreciate it because we do have to be done here in the next couple of minutes.
Thank you, Mr. Chairman. I can do that. Mark Aronowitz, here today for Wyoming Trial Lawyers Association and Lawyers and Advocates for Wyoming, sharing some concerns with this bill.
That was very brief.
Yep, he said he was gonna be brief.
Much appreciated.
Poor Mark.
We're gonna count that against his time.
Fair enough. I don't know, I got dropped, but just sharing some concerns with the drafting of the bill. And I can't tell if it's just overbroad or intentionally overbroad. But first issue is page 2, line 13, the definition of strategic lawsuit. Strategic lawsuit means a strategic lawsuit against public participation. There ought to be a better definition of what a strategic lawsuit actually is and what the next 15 pages are aiming to deter. But just having its own name in the definition of itself seems odd. And then as you go through, top of page 3, with any matter of public concern, and public concern shall be construed broadly. Page 3, line 15, all laws in this state shall be construed to grant qualified immunity for any person in any action, case, claim, administrative proceeding, arbitration. It doesn't say this act, this anti-SLAPP act. It says all laws in this state. It's incredibly broad. And then it does the same thing on page 16. This chapter shall apply to all actions in the state of Wyoming. It seems like it's this one, relatively new isolated bill, but somehow it is affecting the Wyoming rules of civil procedure and all actions in the state and in the federal courts. And, also as a practicing attorney, we have the rules of civil procedure, we have evidence, we have judicial discretion, we have sanctions. If you want to get rid of a frivolous case, That's what rules 12B1 through 6 are for, and you can do it relatively quickly if it really is frivolous. So that it just doesn't seem like a bill that's written tightly and that it's just not quite ready for prime time. And that's all I've got. I know you have a time crunch, and thank you very much.
Any questions, committee? All right, thank you, Mark. Appreciate you.
Thank you.
All right, I will close public comment. Committee, what is your pleasure? Okay, I'll offer just a few comments. I think that, I don't think that any of us would disagree with, the idea that this bill is trying to bring forward. There was some, statement, I believe it was from you, Ms. Russell, that we should move it to the floor for debate. I don't know that whether there's much to debate behind the policy. I think the policy is a worthy policy, and obviously 35 states found the policy to be worthy. My hesitations with this bill are that it's probably the most complicated bill that we've had in front of the Joint Judiciary Committee this entire session. It's a very complicated bill. I think it's worthy of an interim. I think it's something that you need to have courts weigh in on. You need to have more members of the bar than just one or two attorneys weighing in. You need to have a full and frank discussion about the procedure in this bill and the process and the overall policy of it. So I just think that there's a lot going on here, and I don't think we're ready to move this bill forward. I would rather have a much deeper discussion. Obviously, interim topics have already settled. I don't know if it was put in, Mr. Crossman, but I really think this is a big enough bill that this would be something that you could spend an interim on and still have questions about what's going on in the bill and what it's doing and how to best do it. So those are my thoughts on the bill. Committee, anything? So Senator Colton?
Yeah, thank you, Mr. Chairman. Just, and my thoughts are, it's, the downside of this bill is probably is equal to the upside. Trying to solve a problem and causing another problem. I think that I would have been more amenable to have a law from another state that's been proven to be brought in front of me. This is an adventure, and I just think it lacks enough thought. That's certainly for sure. I think nobody likes frivolous lawsuits, and I think that definitely we could always try to improve that. But this, I'm not an attorney, but I'm, I guess, aware enough from listening to this kind of.
You became one today.
Oh, thank you. I was elevated for a moment until I was shot down by my co-attorney.
It's
a
yeah, I don't know if
demotion.
it's-
Well, I'm going to take it as a
I don't know if it's
promotion,
a
but
promotion.
I think I've heard enough in my time that I understand balance and fairness, and I didn't see this in this bill. I know it's addressing a problem, and obviously in good faith, but it didn't get to where it needed to be. It's too big of a lift, and too many things. So that's my comments. Thank you for my ability, Mr. Chairman, to comment.
All right, thank you. With that, we are adjourned right on the 2 o'clock mark.